Hello, and welcome to McKenzie Friend. Today we're going to look at the difficult issue of what if DNA testing reveals the child is not mine? This is a very complicated area, and so this will only be a brief description of some of the issues that may or may not be involved. But first, the usual disclaimer: whilst I hold a law degree majoring in family law, I choose not to practice nor seek admission. Therefore, information can be relied upon. Specific questions should be directed towards an accredited family law specialist. Right. The issue: how does a tort of deceit apply between spouses under the Family Law Act? There's deceit, interspousal immunity, and paternity fraud. Right, we'll look at this case called McGill in 2006, which is a High Court case. Now, whether tort of deceit can be applied in marital context in relation to false representations of paternity, where DNA testing after marriage ended revealed the two children of the marriage were not the biological children of the husband, where the husband claimed damages in deceit for loss of earnings, loss of use of monies, personal injury, pain, and suffering. Now, the relative provisions to this is Section 119. Married persons may sue each other. Either party to a marriage may bring proceedings in contract or in tort against the other party. And Section 120, criminal conversation, adultery, and enticement. After commencement of this act, no action lies for criminal conversion, damage for adultery, or for enticement of a party to a marriage. So, under the Family Law Act, the relevant provisions, Section 43 being the principles to be applied by courts, 48 divorce, 51 nullity of marriage. Now, 66X, recovery of amounts paid and property transferred or settled under maintenance orders. And then 69P, presumptions of parentage arising from marriage or cohabitation, from registration of birth, from findings of a court, from acknowledgements, and then the rebuttals of presumptions under 69U, the evidence of parentage, declarations of parentage, and orders for carrying out parentage testing procedures and orders associated with parentage testing. There's quite a lot of provisions that will apply in these sort of matters. So let's look at the facts in the case of McGill. In late 1989, the respondent represented to the appellant that he was the father of the second child. In early 1991, the respondent represented to the appellant that he was the father of the third child. Both representations were false. On the faith of the representations, the appellant believed that he was the father and altered his position to his detriment. The representations were made fraudulently, with the respondent either knowing they were false or recklessly not caring whether they were true or false. At the time of the representations, the respondent intended the appellant to rely upon them. As a result of the representations, the appellant suffered loss and damage. The damage included severe anxiety, depression, and loss of earnings. Now, at 9, in the circumstances where he obviously believed he was the father and accepted the responsibilities of fatherhood, her silence would have contributed to his belief. Yet in the absence of a legal or equitable obligation to tell the truth, silence of itself does not amount to misrepresentation. Unfortunately, that's just a fact of law. At 12, I'm of the view that the evidence points very strongly in favour of the conclusion that she did know the husband was not the father of either of the children. Certainly, at the very least, in my view, it pointed to the conclusion that when she filed in these forms, if she did not know for a positive fact that McGill was not the father, she at least was being reckless as to the truth of her assertion that he was and had no genuine belief in it. She intended Mr. McGill to rely upon it, and indeed he did, in consenting to naming of the children McGill. Now, looking from the classic case of Derry and Peake, a common form of dishonesty is false representation, fraudulently made, and it was laid down that it was fraudulently made if the defendant made it knowing it to be false or recklessly, neither knowing nor caring whether it was false or true. That is fraud in the strictest sense. So from Langridge and Levy, in another Looks English case, followed down the principles laid in Paisley and Freeman, that mere naked falsehood would not give right of action, but a falsehood is told with the intention that it should be acted upon by a party injured, and that party acts upon it in a way that produces damage to him, an action will lie. Now, of course, these things have changed a little bit since these Old English cases. So there's the 5 elements of modern tort of deceit. That the defendant made a false representation. That the defendant made the representation with the knowledge that it was false, or the defendant was reckless or careless as to whether the representation was false or not. That the defendant made the representation with the intention that it be relied upon by the plaintiff. That the plaintiff acted in reliance on the false representation. The plaintiff suffered damage which was caused by reliance on the false representation. This is just the development of the early principles from Derry and Peake. So, turning back to McGill and McGill, the matters which an individual party to a marriage might properly regard as intimate and private are not limited to questions of paternity of children of the marriage or sexual fidelity or the events that occurred during the marriage. Finding a duty to disclose the truth about some matters would be inconsistent with the ethical context in which such a judgment must be made. Furthermore, the problem goes beyond questions of disclosure. Imposing legal consequences upon behaviour in such a relationship also may be inconsistent with the subjective contemplation of the parties and with which public policy is reflected in legislation. Just important to note that public policy is an important consideration often in these matters. In that connection, the extensive scheme of regulation that legal incidents of marriage relationships are contained in the Family Law Act, based as is largely upon a policy of minimising the importance of questions of fault, forms an important part of the setting in which judgments about dishonesty and actionable damage must be made. The application of the common law of deceit to marital relations is not impossible, and there are no rigidly defined zones of exclusion, but attempts to construct legal rights and obligations in an unsuitable environment should fail, as did this attempt. Now, this is a High Court matter, so there was a full bench. Now, not all the judges necessarily came to the same conclusion, or they came to the same conclusion but through choice of different precedents and arguing different principles. So it's always the majority of the judges that determine the outcome of cases. So if we look at Gummo, Kirby and Crennan, for the reasons stated above, false representations concerning an extramarital sexual relationship or its consequences made by one spouse to another during the course of marriage, i.e., excluding circumstances involving either a duty of care or duty of disclosure, are not actionable in deceit. Nevertheless, a husband is entitled under the family law regime in Australia to seek an order for the repayment of any monies wrongly paid for child support under Section 143 of the Child Support Act, or child maintenance under Section 66X of the Family Law Act in reliance on such representations. So if we turn a little bit towards the Child Support Act, under Section 143 of the Child Support Act, payments can be recovered where a child support has been paid by a person who is not liable or who subsequently becomes not liable. A court has a discretionary power to make such orders as it considers just and equitable for the purposes of adjusting or giving effect to the rights of the parties and the child concerned. Section 66X of the Family Law Act also contains provisions enabling orders for the repayment of child maintenance, which has been paid by a person who is not a parent or step-parent of the child. In this manner, the legislature has evinced an intention to deal with the economic loss caused by the wife to the husband after the breakdown of their marriage in circumstances such as those arising here, namely payment of child support or maintenance. Now, we're going to turn a little bit about child support. We're not going to get very deeply into it, but the Department of Human Services will not accept DNA parent testing report as proof that someone is or is not the child's father. Under Section 160A of the Child Support Assessment Act, DHS will only accept a declaration of parentage from the court. So you have to go before the Family Court or the Federal Circuit Court and seek a declaration of parentage. So, pursuant to a parent seeking a declaration of parentage under Section 69VA of the Family Law Act, the Family Law Court or Federal Circuit Court, a parent would seek orders for parenting testing under Section 69W. If the court ordered DNA test indicated that you are not the parent and DHS is assessing you to pay child support for, you can apply to the court for a declaration under Section 107 of the Child Support Assessment Act. So, in conclusion, there is no cause of action, lies and deceit arising from the discovery that DNA shows that the father is not a parent. A cause of action may exist in regards to the overpayment of child support or child maintenance. I hope this helps.